Good morning, everybody. Thank you for tuning in to CSIS webinar on everything you need to know about standard essential patents, global regulation, and litigation as it's playing out today. As you know, with many important technology standards, in particular 5G that connect billions of smartphones and automobiles and IoT devices, licensing of patents related to this technology has been of a lot of interest, a lot of discussions. And we're here to discuss some of the developments that are going around the globe on regulation, on litigation in China, in Europe, in the United States, and how that's affecting businesses and companies and developments in this area. I have an expert panel for us to discuss. We all live in this space. And allow me to introduce the panelists to you. We will start with a short opening remarks, keynote introduction from Andre Iancu. Andre is also a senior advisor at CSIS along with me. He was one of the co-founders of the Renewing American Innovation Project here, and also a partner on the IP practice at Sullivan and Cromwell. Andre previously was the Undersecretary of Commerce for IP and the Director of the U.S. Patent and Trademark Office. Welcome, Andre.
Thank you very much. Good to see you all.
Allow me to introduce other panelists, Andre, and I will then give the floor to you. On the panel, I have Mark Cohen. He's a research fellow at the Haas Business School at UC Berkeley, and he was the senior IP attaché at the U.S. Embassy in Beijing for almost 30 years of experience in IPR, real expert in China issues. David Long is a registered patent attorney with over 25 years of experience in telecommunications. He runs the Essential Patents blog and is a founding managing partner of Essential Patents, LLC. Eric Stasek, welcome, Eric. He's a founder and managing director of Avica, a consulting firm based in Stockholm, and he has over 25 years of experience in the licensing of patents related to these kinds of technologies. And we have Matthew Noble, who's joining us from the UK. He's the head of patent intelligence at Bird & Bird, where he's a partner. And he's the founder of Two Birds pattern, Bird & Bird's patent intelligence. It's a consultancy offering. So he specializes in portfolio patent valuation analysis. So we have a whole host of expertise here, and I can't wait to get into all these global developments with all of you. But first, let me hand it over to kick us off, Andre.
Great, thanks, Kirti, and thanks to CSIS for putting this program together, and great to be with all these fabulous experts in the field of standards and standards-based technologies. So let me start by giving a high-level view of why we care about innovation in the standard space and what it takes to have such innovation. Obviously, the world is more and more interrelated and interconnected. That is true on the technical space, and of course that results in the need for standards so that various devices can operate together and can cooperate with each other, and companies can interact with respect to particular technologies all over the world. Examples of this include things like cellular technologies, whether it's 5G, we're on to 6G now and beyond, Wi-Fi standards, Wi-Fi 6, we're now beginning Wi-Fi 7 types of technologies. And all sorts of other things, cars on the highways communicating with each other. Devices need to know how to interoperate with each other, and for that, companies have to collaborate, and that's why they create standards. Things even as simple as the plugs that we use to put our, to charge our phones in the walls. More and more now that technology is becoming standardized. Thank goodness, because I've run out of space for the various cables I have to carry. But in order for standards and technologies that make standards operate to be developed and adopted, somebody has to work and do the research and development for that technology to come about. And then different companies have to develop their own technologies, and then companies and industries get together and discuss which standard technology to which technology to adapt into a particular standard, which one is better than the others, and so on. And then an agreement is being made as part of standard setting organizations, and then ultimately a standard is being published. Once that standard is being published, then others can start using it if they follow certain requirements. So, so that whole process does need to take place. There has to be an economic incentive for that to take place. In particular, in a free market economy like the United States, the fundamental question is, what incentivizes a company to put in a lot of resources to develop these technologies that will ultimately be adopted into standards? So for this, we really need to step back and understand the concepts behind the economics of innovation. Because remember, by definition, any innovation is risky business. By definition, innovation is for something new, and you don't know if it's going to work. You can try a whole host of solutions to a particular problem, but you don't know if it's going to work. And the reality is that in the vast majority of the time, the solutions you try to solve a particular technical problem fail and do not work. So therefore, a lot of resources have to go into developing a technology that ultimately works for the intended purpose. This is true of all innovation in every area. So it's risky business. And this is also true for technologies that ultimately end up in standards. However, for standards, there is additional risk on top of that, because you can develop as a company, you can put all the resources and finally develop a technology that actually does work for the intended purpose. However, for one reason or another, the standard setting organization does not adopt your technology and instead adopts your competitor's technology. In that case, you're completely out, and all that effort has been mostly for naught. And this is yet an additional risk to that investment in that particular type of innovation. And on top of that, even if your technology is adopted into the standard, you don't know that the standard will be successful. There are plenty of standards that have been adopted out there that ultimately did not make it into the marketplace and haven't gone anywhere. So there are layers upon layers of risk in a free market economy. What incentivizes a company to invest in such risky enterprise? And the reality is that there are very few incentives, and the one and best incentive that works is the intellectual property system, primarily patents that you obtain for the technology that you develop. Because now that if you have a patent and your technology is ultimately adopted and it becomes a successful part of the standard, then you can obtain royalty rates and license fees for the use of that technology. Without a patent, it becomes much more difficult to monetize. So it's really important for the inventors of technologies that end up in standards to be compensated for that investment. And in a free market economy, patents is the one tool that it has been developed. There's a lot of regulation that countries have put forward to ensure that once a technology is adopted and patents are issued on that technology, that people can actually use that technology. Obviously, you don't want to have a technology adopted, but then nobody can use it. So you have to make sure that the technology is made available to the implementers who want to include those technologies into their products, as long as they pay what is called a fair, reasonable, and non-discriminatory license fee. Different countries have different policies on this. It may surprise people to know that the United States has no policy on standard essential patents. These are the patents for the technologies that are essential to the standards. The United States has had policies as a country, as a government in the past. We've had policies going back to 2013. There was an amendment in 2019, but currently, as we stand here in 2024, the administration has suspended all the prior policies, and there is no formal government policy with respect to such patents in the United States. The European Union is trying to regulate in this area, and our panelists are going to discuss quite a bit about the proposals from the European Parliament in the last year or so. Meanwhile, other countries around the world are trying to take control of the issue. China is a very good example. It's becoming a leading jurisdiction to address standard essential patents, and the royalty rates that are assessed on a global, worldwide scale surrounding such technologies. Because remember, a standard usually applies worldwide, and China's trying to regulate the economics of that. Bottom line is that there's a lot of development in this area. It is critically important so that innovation takes place in the United States if we as a country want to be a leading voice in the standards and the technologies that are being adopted in the technologies of the future. So as you're listening to the conversation today, I'm sure it's going to get into nitty-gritty details of patent policy in this area and economics, but there are much broader implications of international diplomacy, international economics, and U.S. national security as well. So with that, I look forward to the conversation. And Kirti, take it away with the panel.
Thank you, Andre. That was perfect introduction from somebody who's steeped in the space. And I realized I didn't introduce myself, but those who don't know who are viewing this, in addition to being a scholar at CSIS, I am serving as the chief economist of global technology at Cornerstone Research. And before that, I spent a little over 20 years at Qualcomm and as the company's chief economist. But before that, many years as a standards engineer. So I'm very deeply involved in this space, like the rest of our experts here, and we will have an interesting back and forth. I can't wait to get into this with you. So let's just start with a quick lay of the land. As you were describing, Andre, I would like to start with Europe that has recently proposed legislation on SEPs, which has standard essential patents that are deemed as potentially essential to implementing these technologies. And this proposed legislation has now been approved by the European Parliament, and it's awaiting approval from the member states. Now, it covers two main topics, which I would like to get into. Transparency, which is determining which patents are actually essential for implementing of the standards, and second, of determining royalty rates. So, Eric, I'll turn to you. You're calling in from Europe. Would you give us a brief overview, please, of this legislation in Europe and the issues it's trying to address?
Thank you, Kirti. First, thank you for inviting me to be on this panel. I'm in Stockholm, so I'm on the edge of Europe. And what's happening in Europe is that the European Commission, which is the body in the EU responsible for proposing new legislation, submitted a proposal for a regulation on standard essential patents on April 27th of this year, in 2023. The regulation seeks to ensure the efficiency of SEP licensing, facilitating lawful access to standards, and promoting wider access to standards, very lofty goals. This has been a lengthy process, beginning, I think, in 2017 with the Commission's communication setting out the EU approach to standard essential patents. In its intellectual property plan of 2020, the Commission announced that it wanted to further promote transparency and predictability in SEP licensing. And this was followed up by a number of studies, including a landscaping study of SEPs, a pilot study on essentiality checks. They set up a group of experts on licensing and valuation of SEPs, which they called the Commission's SEP expert group. And they issued an impact assessment where the Commission identified the main issues was a lack of transparency, uncertainty and unpredictability regarding licensing costs, and high transactional costs resulting from complex negotiations and litigation. One particular problem driver was the lack of clear SEP ownership and essentiality. Now, all this is being done against the backdrop of the IoT, the Internet of Things, where new, inexperienced, and small implementers will be coming into the fore. So it's primarily focused on SMEs.
Small and medium-sized enterprises.
Yes, exactly. Yes, the draft regulation aims to improve the licensing of SEPs by addressing the causes of inefficient licensing, such as insufficient transparency with regard to SEPs, FRAND terms and conditions, limited use of alternative dispute resolution procedures, and so on and so forth. The important points, the draft regulation would in principle apply to standards published after its entry into force. However, the Commission would have delegated power to exclude new standards or use cases that, quote, do not give rise to significant difficulties or inefficiencies affecting the functioning of the internal market, close quote. And in addition, the Commission would also have delegated power to subject even existing standards or use cases whose licensing, quote, severely distorts the internal market, close quote. Now, the draft regulation comprises a number of components. First will be the establishment of a so-called competence center at the EU IPO, the EU Intellectual Property Organization in Alicante, Spain. Now, today, the EU IPO is the EU's trademark office. They have no experience with patents, but they will be tasked with carrying out a regime of essentiality checks to determine which patents declared to standard development organizations are actually essential. They will maintain a register of SEPs, and SEP holders will be required to populate the register before asserting and collecting royalties for their SEPs. Furthermore, the EU IPO will be tasked with determining an aggregate royalty, sort of the total stack of royalties for a license to all standard essential patents for different standards and different use cases. And then finally, the EU IPO will be mandated with making a FRAND royalty determination on a bilateral basis with the help of what they call conciliators. Now, the draft regulation would also require SEP owners to comply with the requirements of the SEP register and submit to a FRAND royalty determination before they could assert their patents in courts. And this is supposedly going to take 9 months to be done, so there'll be a timeout to go through this process at the EU IPO before you could assert your patents in any of the EU courts. Now, the process has been somewhat unusual. Before the draft regulation was published, 2 previous versions were leaked to the public, and this is highly unusual for things coming out of the Commission. Significant changes were observed before the first leaked draft, the second leaked draft, and the final draft, which was published in April. And you can see that the Commission was responding to hysteria that met the first leaked draft. Notably, the leaked versions and the final versions were full of inconsistencies and ambiguities, as well as numerous typographical and formatting errors. This is something highly unusual for a work product coming from the European Commission. You don't normally see this, and particularly you don't normally see it as bad as it was. And I've been told that the drafts were leaked by another organization within the Commission called DG Comp, who were appalled at the poor quality of the draft regulation. Now, the proposal was formally issued on 27 April 2023 to the EU Parliament. And that's the 720 members who are subject to direct elections by EU citizens. And we just had an election here in June for an EU Parliament. In the draft report there was a draft report published in October 2023 by Marion Walsman, who's a member of Parliament from Germany. She's the head of the Legal Affairs Committee. And they proposed a wide range of amendments to the regulation as it was received from the Commission. On February 28th of this year, 2024, the Parliament in its first reading approved the proposal, adding 268 amendments to it. And the vote was overwhelmingly 454 to 83 in favor, and then a bunch of abstentions. So the regulation has passed the first parliamentary hurdle. The next step in the EU is the regulation will now go to the EU Council, which consists of the head of governments of the 27 EU member states, the president of the EU Council, who's currently Charles Michel, the former Belgian Prime Minister, whose term expires in November of this year, and the president of the European Commission, Ursula von der Leyen, who was recently reselected as president of the Commission by the newly elected EU Parliament. Now, the Council can adopt the proposal as it's received from the Parliament. It can introduce amendments or can send it back to the Parliament for a second reading. Now, most recent thing that's happened is that DG GROW, which is the organization within the European Commission who issued this proposal for regulation, they issued a tender for a report on implementing aspects of the draft regulation, which was a little bit strange because a lot of the things one would think should have been done before they issued the proposal, but they're doing it now. And the tender is asking for a report or a study, including 3 different tasks. The first task is a methodology to define the scope of the regulation, which includes an overview based upon the market analysis of the entire landscape of standards that would potentially fall under the regulation. And this is an important aspect because the SEP regulation isn't limited to 3GPP standards or IEEE standards or telecommunication standards. It applies generically to all standards that are used in the European Union, so everything. The second task in this tender is to develop and recommend a methodology for essentiality checks, which is also a little curious because the Commission had previously commissioned a pilot study on essentiality checks that looked at several different ways that these essentiality checks could be carried out, and they concluded that this could be done at scale. And the third task is to define an implementation plan for the regulation, how to best set up the register, how to identify these people who will work as conciliators, and so on and so forth. And that just came out. Let me just finish real quick. That just came out, and the proposal, the time limit for submitting proposals for the tender is 26 August, and then there's a 9-month period of performance for this tender, which suggests that given that the Council meets every 6 months, no decision will be made on the regulation until late 2025 or early 2026.
I appreciate the full landscape. This is great. I do want to spend a few minutes. I would like to turn to China. But before that, I would want to spend a few minutes on the implications of a lot of process and discussions that we've heard and the highlights of the regulation. So it's essentially 2 big steps. One is this identifying like what you call essentiality checks. So what are, potentially essential patents? In other words, there are tens and thousands of patents in technology standards and the big ones sometimes, and that's because these are big, complex, hundreds and thousands of documents sometimes of systems. And it's not always clear which patents that are declared are truly essential. Now, it's curious that it's been given to the trademark office, the EU IPO in Alicante, Spain, with little experience. And second, it's a tough thing to do with a lot of resources, with with great technical skill sets and engineers and patent attorneys. You're still chasing, moving targets, right? It's hard to identify. And then the other thing is rate setting. The setting of royalty rates and determining what the price caps or royalty caps will be. I would like to hear from other panelists what they think would be the implications of a legislation like this. Very briefly, few sentences. How do you think that's affecting, business decisions or potential litigation in Europe? Mark, you want to go?
Sure. In terms of the interplay with China on that topic of how EU rate setting would affect things globally, China is not going to give up on its sovereignty over rate setting. It views that as too core to its national interests. But low rates, rates that it would consider reasonable under the various FRAND pillars, would be acceptable to it as a comparison. And they have used comparison rates already in various FRAND rate setting cases. And I think what they're really trying to do is come up with a rate that's sufficiently low that it helps China's industrial policy, but sufficiently high or modestly high that it doesn't trigger a WTO dispute, some kind of diplomatic kerfluffle with another country, and that it kind of forces the parties into thinking, typically the foreign licensor, they're thinking, is it going to be worth the trouble for me to bring cases elsewhere or to challenge this because it's going to cost me in terms of government relations and money and time. So I think a European rate could have a downward driving, a supporting effect for Chinese rate setting.
Hey, Curtis, you're muted.
Thank you. Speaking of that, there's so much development in China on the heels of this, this European legislation happening. But in parallel, Andre alluded to this, right? Like what you're saying, Mark, China has been positioning itself to become the jurisdiction of choice for resolving SEP disputes or disputes around these patents and setting global royalty rates. Could you help us understand some of these key legal developments? I know you follow them closely in your work.
Yeah, so it's a pleasure to be here. Pleasures to join the discussion. There's been a lot of drama over the past 10 years or so involving China's efforts to set FRAND rates, push off foreign courts, set a global rate, support anti-suit injunctions. And some of it has actually come with a fair amount of cost. I think the Chinese system today is somewhat less predictable in terms of the tools, but fairly predictable in the direction they're heading. We've had cases coming out of relatively obscure jurisdictions like Wuhan. We've had judges who have filed cases that don't get into databases because they're contrary to the trend. We've had real transparency issues with cases not being published. We have efforts to bend legal doctrines like behavioral remedies for anti-suit injunctions. And we have jurisdictional rules that are changing, choice of law rules that are changing, and all of this is somewhat sui generis to FRAND cases. At the same time, China's trying to become a global center for international IP and international commercial dispute resolution, and there's almost a contradiction or friction between the two. So what does that landscape look like over the past 10 years, and particularly the last 4 or 5? Is begin with Huawei versus InterDigital. China took an aggressive approach to the overseas filing of a ITC case and viewed that as basically a per se violation under its antitrust laws. And so there are antitrust damages, and also there was a low FRAND rate setting ultimately. Huawei versus Samsung, a very similar case that actually surprised the Chinese because the U.S. is parallel with the U.S. court proceeding. But then you get into cases like the Conversant case, Samsung versus Ericsson, and others, where there is an increasing interest in pushing off foreign cases by supporting anti-suit injunctions to stop the parties in a foreign court proceeding from pursuing litigation, even though patents are territorial. And even though China previously, if we had this discussion 15 years ago, it would probably be unthinkable to Chinese practitioners and academics because China was so wedded to a territorial notion of IP. They wouldn't even cooperate in many areas like sharing of prosecution data, which we have, patent prosecution highways and the like, because this was tied up with their notions of sovereignty and territoriality, and anything else was some kind of a colonial type approach to intellectual property. Now you have China thinking the complete opposite way, and you have to wonder, is that geopolitical? I think this is because China is feeling they have the power now to make those determinations, and it's certainly tied up with their own sense of economic security and their desire to have sovereignty, and they use that word frequently in the courts over FRAND rate setting and over their courts. But this has enabled some courts, like courts in Wuhan, to issue anti-suit injunctions, although now we don't hear from those judges that often, I think because the EU court case of the WTO case that the EU filed has kind of put a damper on that court and on anti-suit injunctions. And more recently,
let's pause on that, Mark, for a minute.
Yeah.
So I think you just mentioned a complaint that was filed by the European Commission at the WTO against the use of anti-suit injunctions from China to keep jurisprudence in China. So can you just double click on that before you move on from that point?
Sure. So there's some elements of the EU complaint that are longstanding, but basically one of that aspect is transparency. The EU is trying to get China to publish these cases, make them publicly available. And for the most part, they have been made publicly available, not necessarily in a timely fashion, but it's a hard thing to confirm. The other part of the case, which is quite interesting, is that the EU has basically said to China, these anti-suit injunctions that your courts have issued interfere with the access to European courts by European companies. And since it's a WTO obligation, a TRIPS obligation to have access to the courts to enforce your rights, you're not permitting us to enforce our WTO rights domestically, or you're trying to interfere with that. So that part is still outstanding. The transparency part has been a little bit weakened. But the other part, which is really important here, is that WTO remedies are largely prospective, so that since China has basically put anti-suit injunctions on hold, exploring other remedies like global rate setting by the courts, the effect of a judgment in this case would be a little bit unclear. There's a third aspect here, which I think is really important to note, and Andre and I have written on this, which is that the US, we talk about global regulation and global rulemaking, has largely supported China in this dispute. And the reason they've done that is probably unrelated to SEPs, but they don't want to be compelled to produce internal policy documents. And the part of the EU complaint is that China has a lot of internal policies regarding anti-suit injunctions, SEPs, and FRAND rate setting, and they should be made public because they're basically regulations of general application. Very important point relating to transparency, one where I think regrettably the US is on the wrong side, but it's also a part of the overall case. I think it's about 19 countries have joined this dispute as observers, a wide range of countries. It's still in process.
So I'm going to put maybe Eric, you in the spot here, and maybe you, David. So help me understand, and our listeners. So China filed, EU filed this complaint at the WTO, and Mark says one of the concerns was that European companies won't have sort of this access to the system in China in a transparent way. And in the meantime, this proposed legislation in Europe that Eric, you were talking about, isn't one likely impact of that basically reduce litigation in Europe? Because, basically, it's a regulatory framework that is suggesting resolution of rate setting outside of the courts. So are we likely to see more litigation in China? Moving to China?
Well,
if I could
go ahead.
I'm sorry. Sorry, go ahead, Mark.
I just wanted to say that there are certain advantages to the Chinese system. The government meddles in it a lot. But I just want to put out there that before China had anti-suit injunctions, they had a huge advantage, which is that court cases are fast. And if you have a huge market, you get your first instance decision in 6 months and your second instance in 3 months. I would tell Chinese friends, you don't need an anti-suit injunction. You can have your final adjudication of the case within 9 months before the US has even initiated discovery. In a huge market, you're going to bring the parties to settlement discussions. So there is, in the fair competition among jurisdictions, China has certain advantages, including expert courts and expert judges.
Thank you, Mark. Eric?
What I was going to say, Kirti, is that the European Union's proposed regulation is something of an own goal with regard to their complaint with the WTO, because the one of the major complaints about the EU's proposed regulation a lot of European judges have pointed out, is that this 9-month period of conciliation at the EU IPO, during this period of time, you can't turn to the courts for adjudication of your patents. So there's a period of denial of justice by the EU's own regulation.
China, right?
So I mean, it's the pot calling the kettle black now a little bit. So it's a little bit ironic that they've done that, and I think it interferes with their WTO case.
That's right. So I think there's a contradiction there in Europe. So David, you were saying something?
Yeah, my thought too is there may be a little bit of a wait and see or hesitancy of what to do here. When you look at this was very quickly thrown together by the European Commission. And part of why in their background, they talk about other countries are doing things with SEPs and global rates. Maybe we ought to as well. And so I took to heart Eric's comments that some of this initial regulation that came out was kind of sloppily done. When you looked at it, there's comments received after this came out, and the EC as well as the European University Institute analyzed those comments. About half the people favored the regulation, but half the people didn't. And when you have that kind of half or against, why are you pushing this through? When you looked at the comments from countries, about a third of the comments received to this regulation came from the United States itself. And when I think about that, it reminds me of the story you've probably heard. Two people are in a lifeboat. One of them grabs this little hand drill and starts drilling a hole. And the other guy said, "What are you doing?" He said, "None of your business. I'm just drilling it underneath me, the hole in the bottom of the boat." And of course, I think there's some concern here when you get a third of the comments from the United States that what are you doing? So I think this it didn't surprise me they had a lot of amendments of this regulation when it first went through, but there may be a little bit of a wait and see approach as to proceeding in litigation in Europe to see what they've done.
And there are other places in Europe just outside the European Union where people can bring these cases, right? So we had a case management conference last week on a case that set a 20-day FRAN trial for June 2025. So that's 11 months. Not very long at all for a UK case. If you look at the obiter comments of the judge in the Interdigital Lenovo case, you'll see Mr. Justice Mellor. He was trying to set a precedent that essentially courts in the UK or England and Wales could follow afterwards to speed up these disputes and make them cheaper. And there's a question mark as to whether that's going to happen. But what I do know is that the UPC is struggling to sort of meet its target of 12 months to trial in SEP cases. That's starting to become clear. What is also clear to me, but maybe it's just I've been on different cases to Mark, is that FRAND in China is not always that fast, right? It can be very fast, but it seems to be at the whims of the parties or the particular judge, right? And it seems like there is not going to be one FRAND determination trial. There's going to be two, there's going to be three. And if new issues come up, it can just drag and drag. And I know we're getting to the Nokia Oppo Chongqing case later in the talk, but
Matt, you bring an interesting perspective from the UK and seeing some of this global litigation. I want to turn to that, and just because I think where the discussion is going is China can move fast. It has all these tools like anti-suit injunctions. And in exactly the same time, Europeans are passing this legislation where they're saying, well, we're going to try to do this process outside the courts. And for 9 months, we can't even have access to the European courts. So there's almost more of an appetite, it seems, for some of the litigation moving out of Europe into these other jurisdictions that you're describing, unless the UPC can, the Unified Patent Court in Europe can have an expedited process that is a meaningful competitor.
Well, just to make one point on that, we've seen a flurry of implementers seeking expedition of their FRAND cases in the UK. Not all of them can be accepted, but there's definitely been a move into the UK in that regard.
Interesting. In all this, David, where does the US sit and stand? So there's we're probably the most litigious society, at least traditionally, and there has been a lot of interesting, important development in this space, in the standard essential patent France space in terms of jurisprudence in the United States. What are our big lessons learned that we can take and apply?
Yeah, thank you. And for what it's worth, there has been a lot of litigation in the U.S., but that's because we have one of the best systems for coming out to fair and equitable outcome that you'll find in the world.
Right.
And so I'm very proud to be a U.S. attorney. But anyhow, it's interesting in looking at these developments. It's actually been 10 years now since a lot of issues that seem to be battled elsewhere have been decided in the U.S. And I say that because in almost 10 years ago now, I guess, in 2014, the Federal Circuit decided two key things that have been a constant battleground with SEPs, which is you can't get an injunction if you have an SEP. There's a per se rule that you can never get an injunction. And the Federal Circuit and Apple v. Motorola said, well, that's not the case. Just apply our standard. If you apply our standard that you apply in all patent cases, you'll probably find it'll be difficult to get an injunction if you promise to license everybody under a FRAND rate or some other rate. If you're going to license a lot of people in exchange for money, you're going to have a hard time getting an injunction. But there could be cases, if you have an unwilling licensee or other things, there may be cases where you should get an injunction. So just apply our standard. We see the same thing then with the royalty. Erickson v. D-Link decided in 2014 as well. People are saying you got to do this very special modified Georgia-specific factor test to determine damages for standard essential patents. It came out from the Microsoft v. Motorola case from Judge Robart. The Federal Circuit said, no, there's no special rules of damages for standard essential patents. Just apply the framework. You know, some Georgia-specific factors may apply, some may not. You know, if the factors don't apply, don't tell the jury about them because it doesn't matter. In fact, you don't have to use Georgia-specific at all to determine your damages, but there's no special rules for standard essential patents. And then you also hear that argument about the smallest sellable patent practicing unit, the SSPPU. That's being a big battle as well in the standards area, as well as generally with damages. And the Federal Circuit said there's no rule that you got to use the SSPPU.
Yeah, quickly translating this for our audience, it's the idea of, you can set the royalty rates at any percentage, but this is a discussion about what the base would be, because any royalty is a multiplication of the rate times the base. And if the base is too small, then you can have a very big rate, but you can still end up with a very small royalty rate. So there's been a lot of discussion there. Go ahead.
No, thanks for the clarification. I get so steeped in this stuff and so excited about it because I find it fascinating. But what royalty rate do you use? You have a Wi-Fi standard that's implemented in a chip, but then that chip is used in multiple different products. Should your royalty base be the cost of the chip, or can it be based on the cost of the ultimate end product that uses it? And the Federal Circuit said, just use our standard way of doing damages, and you can do that, or you don't have to do that, as long as at the end of the day, what you're doing, it all makes sense. And then the one last battle that I'll talk about that we see a lot going on is where in the supply chain must you license? You'll see there a lot of mischief was done in this Microsoft v. Motorola case in the Ninth Circuit, where in the background factual section, the Ninth Circuit had a throwaway sentence that under the brand commitment, you agree to license all comers. And so people grabbed onto that background factual statement that us U.S. attorneys know doesn't mean anything. It's not the ruling in the case. They grabbed on that and say, aha, so if I make a chip and I sell it to someone that puts it in a phone or a computer, you have to give me a license if I ask for it. So you have to license further up in the channel versus licensing that ultimate end product, that phone, that computer, whatever that chip is used in. And the Ninth Circuit has held that, no, you don't have to do that. You don't have to license at the component level. If you're licensing the end product, that's fine. Well, you're doing that because you want to make more money. Maybe. You also have concerns of patent exhaustion. Right quick, patent exhaustion means if I license this component of the supply chain, they're licensed everybody else below it to use the invention. And so there's issues of administrative efficiency, et cetera, why you'd want to license at the end product level. So that's a battle that in the U.S. has generally shown, no, you can, in fact, in Erickson v. D-Link, the Federal Circuit said, you can use any royalty base you want to. as long as that times the royalty rate equals the value to the invention. So I'll stop there, but I think in the US, we've seen things go where you think it should go, but I think some of those battles are still happening elsewhere.
So it's interesting. I think it aligns with Andre's comment on the policy framework in the United States as well, that, whether it's the, there are no special rules for standard essential patents in the United States. And the courts have basically followed that approach, with regard to seeking of injunctions, valuation methods, how do you determine, the level of licensing, where in the value chain you're licensing, or the royalty base for determining the royalties. There aren't special rules, but we follow the standard frameworks in the courts. And that's a helpful clarification, and it's in alignment with the way the policy direction has gone in the United States. And in the meantime, Matthew, I think I'll turn to you now. There's been a lot of discussion. I think I would just like to hear from you a little bit about where you were going with, some of the key developments in the UK and in the global litigation in this space, in particular in China, from some of the recent SEP FRAND cases. What are we observing, and is that in alignment with what David was laying out for us?
Thank you. Yes, I'd be happy to, Kirsty, and thanks for having me. So, as we know, the UK courts since Unwide Planet and Huawei have been willing to set a FRAND rate, right? Now, so it's a different approach to that we see in Germany, we see in Spain. Some cases in the UK are willingness based, but ultimately, if you submit to the jurisdiction of the UK court, you're generally thought to be willing. And that has sort of was in question the last couple of years with the Interdigital Lenovo first instance decision, where Interdigital was found to be unwilling at first instance. But if you read the Court of Appeal decision, which came out this month, you can see that really the Court of Appeal had clarified what they're talking about is during negotiations. So they've kind of this question mark as to whether Interdigital were willing or not is now confined to the negotiations. And ultimately, the Court of Appeal decided it wasn't even an important enough question to determine, because the question is, what's the right rate? Now, as you know, the case law in the UK really started with Unwide Planet and Huawei, where you had a comparables case and you had a top-down cross-check. Ultimately, the court went with Mr. Justice Burse, as he went with one comparable, but he put this top-down cross-check in place. Now, the rate that was implied by his cross-check was 8.8% aggregate royalty burden for 4G, right? 4G multimode, which pretty much everyone knows. But what's less publicized is sort of the reason he came to that 8.8%, which is he was looking at the implied aggregate royalty for 4G from the parties. Unwide Planet's case implied 10.4%, Huawei's case implied 13.3%, and 8.8 was close enough, the number he got from his comparables approach, to those numbers that he was happy. So everyone, of course, has run off with this 8.8%, but really anything between about 8 and about 16 would have probably been close enough that it'd have been absolutely fine. Whereas, of course, if we move across the pond and you look at TCL Ericsson, those rates really came from the ex-ante statements made by companies like Nokia at the beginning of the 4G era. And we just don't have those statements for 5G, right? Companies have set their rates, but they've been a lot more cagey as to what they think the correct aggregate is. And that leads to sort of the international case law that we're facing now with the problems of top-down and the way it's gone. And just bringing you to sort of, say, the Nokia Chongqing case and the ACT Oppo case in China, you can see that the Chinese court for the first time has accepted comparable licensing approach, right? I think in ACT Oppo, the court said the prominent advantage of the comparable license approach lies in its ability to reflect market pricing. So we've seen China start to move into adopting a comparables approach, but it hasn't given up on the top-down approach. And you can see that very clearly in the Nokia Oppo case, despite the fact it's been vacated, despite the fact
let me pause here again and do a translation function. So what Matt is saying is, I think, in terms of valuing and determining the right royalty rates or the royalty rates for a specific case, usually courts have applied this method of comparable license, and that's very intuitive for anybody to understand. From an economic perspective, when you buy a house, you look at comps, you look at comparables around your neighborhood, and you see what the other houses are selling for. So you're going with the market defined price. Now, then there's this other approach when that people have found enticing sometimes, and it has its bag of issues that I'm sure, Matt, you can address, where it's attractive to think of a formula that you can latch onto, and you can say, hey, I'm going to say that there's going to be a certain percentage of royalties that add up across a certain standard, like 5G. Let's say it's 10% or 8%, whatever number you said. And then in order for me to determine who gets what licensing fee, I'm just going to divide that percentage across different patent owners based on the number of patents they each have. So if David has 10 patents and I have one, then David gets 10x more than me out of this well-defined pie of royalties. And I would love to hear what the Chinese courts have been doing vis-a-vis this approach and versus the comparable licenses approach. Back to you.
Yeah, of course. So thank you. Historically, I think people believe that the Chinese courts are always going to go with a top-down approach, right? Since the Huawei Conversant case, I think litigators in China dismiss the Chinese court accepting a comparables approach, and that's really quite recently changed, which is quite interesting development. The top-down approach is still present and correct in the Nokia Chongqing case, but there are some quirks of the top-down there, which have kind of carried forward from Huawei Conversant, which from an international practitioner's perspective don't make a lot of sense. So for example, in that case, the 5G multi-mode royalty rate is still lower than the 5G single mode royalty rate, right? Because of the quirk of the formula used in the multi-mode weighting. Now, I don't think anyone thinks that's correct.
So wait, so the technology that's a superset is...
It's cheaper.
Its value is considered lower than the subset?
Yeah. On
How
top
did that
of
happen?
that, well, it's just a mistake in the calculation, in the formula. You can see it right there in the maths, and it just got carried straight over from Huawei Conversant. The same problem applies with respect to the finding that the 5G aggregate is lower than the 4G aggregate. Now, it's hard to see exactly how that finding came about, but it is clear that the decision came on the basis of a hedonic regression analysis put in by Oppo's expert, Dr. Gong Zhong, which we understand. You can see from the redacted version of the vacated judgment that it wasn't able to be fully tested by the other side. Now, just to pause for the benefit of some of our viewers, a hedonic regression is essentially an econometric analysis where you try and work out, taking into account all the factors of the phone, the change in battery, the change in screen, etc., how much consumers are willing to pay for 5G over 4G consumer surplus. The other way to do this is, for example, we've seen in recent US ITC cases, a consumer survey where you ask people how much would you pay for a 5G phone over an otherwise identical 4G phone. But this remains a problem, I think, in our world. And if that finding that 5G is worth less than 4G that comes out of the China decision, that could have an enormous effect on disputes around the world and this industry, I think.
Is the first decision that has tried to set rates for 5G, global rates for 5G. So it would be interesting to see how this plays out. So I think we've heard, so thank you for taking us, several feet deep in the valuation methodologies. But I think the overall fact remains, which is what, Mark, you had laid out, that a lot of this litigation activity moving to China has important implications in a global way, right? So we drew some parallels between the proposed European legislation and some of these recent developments. We've talked about the contradiction that seems to be playing out in the European policy, vis-a-vis this being wary of the anti-suit injunctions in China and complaint filed at the WTO, but in fact, the regulation in setting rates in Europe, in a regulatory process outside of the courts. What are all the implications of all this going forward? I would like to end at this note, keeping in mind, some of the themes that Andre had laid out. What developments should we be on the lookout for, and what are the takeaways we should be thinking about? Perhaps that could be our end note, and if we can keep it brief, I would like each of you to have your final remarks. Mark, let me start with you.
Yeah, well, I think from a China perspective, I think the Fran case has put tremendous stress on China's legal environment. And there's a range of other issues I didn't mention, including, for example, highly inconsistent translations of Fran that are not apparent to the Western observer, that really call into question about how predictable the system is and how much perhaps it's results oriented, or perhaps they're discovering new things. This kind of silent case law development, and I think Matthew just gave a great example between Conversant and Oppo Nokia, where they're picking up cases even though they're not calling them precedential, also is quite interesting. China's going to continue to have an outsized role in SEPs and FRAN matters because it's a big market and they have major players and there's a major patenting going on, and it just can't be avoided. On the other hand, I think other markets are going to continue to exercise an influence, and not just the developed world. We saw a test case in Indonesia. I wouldn't be surprised if we see a FRAN case in Turkey, and certainly we've seen India becoming increasingly important. And I think all of these other countries are also going to put pressure on the Chinese system and make it a little harder to take this kind of extremely nationalistic view of FRAN and SEPs. Although it seems like nationalism is on the rise, hopefully this can be contained so that the SEP and FRAN system truly remains an international one.
Interesting. Thank you, Mark. David, can I go to you next?
Yes, thanks. It'll be interesting to see what happens, of course, because I think a lot of countries are looking at what's happening in the EC and what's happening in China, and should they step in and develop their own system. From the U.S. point of view, for me, I find it interesting, both the UK and the U.S. courts have held that Chinese patents have about half the value of U.S. and UK patents, yet we're seeing they're having a lot of influence here, and that's kind of concerning. When you look at due process in the U.S. compared to China, I think Mark had mentioned the Samson-Erickson case. In that case, Erickson had what we would call a preliminary injunction filed against them. They didn't find out until after it was entered in China that they're being enjoined for something they didn't even know existed. And so I think that was that's kind of concerning from a U.S. Point of view as well. So, the U.S., we develop law at the rate of common law, and that's relatively slow and steady, but at least you don't make mistakes like the European Commission may be making them do with their drastic change. What should we do while this is going forward? It's not clear, but I think on an Unwired Planet case, I thought the UK court did a decent job of saying if we value patents for some other country in a way that they don't agree with, they can evaluate it and we'll adjust what we're doing based on it. I don't know if that is the solution, but I think we need to look at it so that other countries like China don't give us their solution.
Interesting. Matt, can I go to you next?
Absolutely. So I think the EU Commission is trying to solve what's perceived as a transparency problem in SEP licensing. And if you look at the materials which sort of built up to this draft regulation and the European Commission SEP experts group, I think there is a consensus that transparency could be better. People say it on both sides, right? But and they've tried to solve that with this draft regulation, right? But that's not, of course, the only way to deal with it. We've seen the way that the UK IPO wants to deal with it, with sort of a low regulation approach. So they've just published last week their new SEP resource hub targeted at SMEs, and they've announced their cooperation with the USPTO on SEPs. So it's unclear whether something as heavy-handed as the SEP regulation is needed. However, what is clear is it's getting harder and harder to see what's going on, right? In our latest patent database, we've got 48,000 granted 5G families and 74,000 5G families in total. 74, we're getting to the point where we're
patent families.
Patent families, exactly. We're getting to the point now where we're about 4x past the 4G numbers, and some of our modeling suggests we're going to end up with 160,000 5G patent families by the end of the generation, versus a few hundred for 2G, a few thousand for 3G, maybe 10,000 for 4G. So it's not getting any easier or any cheaper. And unless the industry comes up with a way to create this transparency, there's a risk that the Commission just plows forward. Just on the regional discounts, I'll say, interestingly, in Nokia and Oppo, the court used not a 50% discount for emerging markets in China, but more like a 36% discount. So that's moving more in the direction I'd expect to see. But interestingly, if you look at how the Chinese court came up with the rate for the Chinese discount, they looked at Mr. Justice Burse's decision in Unwired Planet.
In the UK. They looked
at
a UK decision to determine the discount.
The Chinese discount, as well as TCL, Ericsson, and Huawei Conversant, and they just averaged all the numbers. So there's no logic to that. They just averaged the overseas decisions.
Averaging overseas decisions. Eric, you're last.
Yeah, I don't deserve the last word, but I'll do what I can. I see a more difficult licensing environment. I already see that the tendency of the willingness of courts to set FRAN rates, is particularly based upon comparables, is making license negotiations more difficult, because you don't want to create a comparable, an unfavorable comparable. And there's a lot of gaming going on between the parties to make favorable comparables. So the more this goes on, the less those comparables actually reflect market value, and they reflect what this value it might have in litigation versus others. So that's the one thing I see. And the other thing I see is that with this conciliation process at the EU IPO, this is a non-binding process. So we're only going to get a recommendation from conciliators. And I think this as well is going to further complicate and slow down licensing on bilateral licensing. First, you have to wait the 9 months to get this conciliator's non-binding opinion, which we don't know what it's going to be. And if it's low, it's not going to help anything. If it's high, it's not going to help anything. And I don't think anybody believes they're going to get it right. So I think that all of this is going to result in a even more difficult licensing environment for SEPs and more litigation.
More disputes. So as this area is evolving, what occurs to me, each of you are saying from your own vantage point, technology is becoming more complex. There are more patents than ever. Valuation methods are becoming more complex. The regulatory environment is becoming more complex. There are these developments in Europe, in China, and the litigation is becoming more global, more to unpack. So just following this and keeping on top of all these developments and knowing the interplay seems to be a job in itself. So with that, I think these are all good takeaways. We're all going to have to see how this space evolves, and the licensing and the litigation and the valuation frameworks evolve. And we're all going to have to keep up to date. So I would like to end our conversation at this point, but begin with, start also a beginning of something else. We have to join our resources and just write together some update of these key developments that we discussed on this panel. You guys spoke so much important jargon and important cases that you just, referenced in passing, but we have to put them all together and just publish it for our listeners and those who need to follow this space closely as it impacts their businesses. So please follow us at CSIS, at the Renewing American Innovation Project, and we'll be writing about this with this expert audience, and we'll be in touch. Thank you all.
Thank you.